Thanks for joining this episode of the Number 86 lecture series, where we discuss classical and modern jurisprudence. Today's episode features Lee J. Strang, the John W. Stepler Professor of Law and Values at University of Toledo College of Law. Professor Strang writes and teaches about originalism, constitutional law, property, and religion and the First Amendment. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Let's talk specifically about the natural law tradition in the American founding. Were the Founding Fathers consciously invoking natural law? Where do we see evidence of this in the Declaration and Constitution?
So the first thing I heard you talking about was the extent to which the American founders, the people who founded the United States, the people who framed the Constitution, the people who ratified our current Constitution, to what extent did they believe in the natural law, were participants in the natural law tradition? And there are some debates on that, but I think that the mainstream view is that the American founders believed in the natural law and were part of the natural law tradition. And in particular, they believed that there were non-posited norms, non-positive principles that if one followed, one was going to have a healthy and happy life, and if one didn't follow, either as an individual or as a community, then one was going to have a less healthy and less happy life. And you see evidence for that all over the place. You see the evidence for that in the official documents, and so the Declaration of Independence refers to God and refers to the principles that come from the createdness of human beings, in the endowments that us as created beings have. You see that in their contemporary writings. You see that in the people that influenced the framers and ratifiers. So it's not a mistake that in the American educational system at the time, the framers and ratifiers were educated, and one of the people that they read always was Aristotle. They read people from the Scottish Enlightenment who were translators of Aristotle for them. And so the natural law tradition was something that was a part of the American founding, framing, and ratification period. I think the best reading of the natural law tradition is nuanced, and what it does is it says that there are two types of human laws in their relationship to natural law. So one type of human law are those direct proximate conclusions from natural law norms. So one direct proximate conclusion of a natural law norm would be that humans should not kill innocent human beings. And those are taken from natural law propositions such as do good and avoid evil, that life is good and worthy of protection, worthy of pursuit. And then the positive law of don't kill innocent human beings is a direct proximate conclusion from those natural law principles. But there is not a lot of human positive law that are derived in the form of syllogisms from the natural law. Instead, the vast majority of positive human law is derived through a different process, one that Thomas Aquinas called determinatio. And he analogized the process of determinatio to an architect. So if you think of, let's say that you want to build a house, and you go to an architect, and the architect and you both, even without saying it, know the minimum conditions that the house has to have. It has to have walls, for example. It has to have a roof to keep out rain. It has to have windows to allow natural light in. It has to have heat. It has to have water and electricity in today's world. In any functional house, those are the conclusions that every person always and everywhere has to draw about what counts as a house. But then think of all the other things of the decisions that one makes in designing a house. What color is the paint going to be? Where's the door going to be located? How many windows are you going to have? What kind of heating and cooling system? Is it going to be geothermal or is it going to be natural gas? And so there's creativity in the decision about those determinatio aspects of building and designing a house. Similarly with human positive law, there are lots of aspects of human positive law where one has to make a decision, the community has to make a decision, but there's not one right answer to what that decision has to be for each particular community and for all communities for all times. And so, for example, think of the United States. The United States, our framers and ratifiers made a number of choices, choices that they had to make, but choices that they made that weren't required by natural law. So it's a choice that one has to make to have a government, and in the modern world, a national government, but you don't have to have three branches of government. You don't have to have Article 1, Section 8 listing Congress's powers. You don't have to have a judiciary like our federal judiciary that's relatively limited. And so the framers and ratifiers made these creative choices. They were constrained because you had to make these choices, but they were still creative within that sphere of constraint.
It makes sense that the natural law wouldn't answer all of the questions that need to be addressed by positive law. Can you give more examples of how natural law might inform these types of positive law choices?
The American legal system is full of positive law, both in the text of the Constitution, and then I'm going to speak in a moment about constitutional precedent. And I think that's an essential part of the natural law tradition. And in fact, in a way, it's homage to the rational capacities of human beings, the rational capacities of our framers and ratifiers. So if you were James Madison and Company in 1787, and you look over the United States, you had the Articles of Confederation, and it wasn't working very well. You saw that, for example, it didn't have an interstate commerce power, and so you had different states that were having trade disputes. You saw your national government that didn't have the power to tax, and so it was perpetually lacking money. There would be requisitions to the states, but then the states wouldn't give the national government the requested money. And so the national government wasn't able to do the basic things that national governments were meant to do, like provide national defense or internal peace over trade. James Madison and the other framers, they knew they needed to do something different. They knew there needed to be a national government. It had to have some certain governmental structures, but within those really broad bounds, they had a lot of creativity, which they exercised using their practical wisdom to craft our current Constitution as a response to the problems that they saw and the problems that they foresaw into the future. So, for example, our Constitution in Article 1, Section 8 has the Commerce Clause. The Commerce Clause was the creative, non-natural law determined solution by our framers and ratifiers to the problem of disputes over trade by the American states. Our Constitution itself is populated with positive laws. Now, those positive laws are consistent with the natural law, but not required by the natural law. And so I think the positivity of the American legal system is, in fact, something that's entailed by the natural law tradition. And there's a second way in which the positivity of the American legal system is a product of the natural law tradition. So when you look at the text of the Constitution, I mentioned the Commerce Clause earlier, the Commerce Clause has very few words. Congress has the power to regulate commerce among the several states. And that gives some information, but if you think about how should a legal system instruct governmental officers, both federal and state, instruct citizens, at that point you had 13 states, and then today, of course, we have 50 states spanning the continent with 320 plus million people, that those few words by themselves are not going to be sufficient to give guidance to officers and American citizens about how to maintain trade peace among each other. And so I think wisely, our system of government, using Article 3, using the judicial power, requires federal judges to adjudicate cases and create precedent. So precedent, in fact, in our system is a form of positive law. It's one that is, I think, an essential mechanism in our legal system, because what it does is it elucidates, it implements the meaning of the Commerce Clause over a period of centuries in a series of cases and builds out the meaning of the Commerce Clause. And so that positive law, the U.S. reports, it dwarfs the size of the U.S. Constitution. And that positive law is massive, but it too is, I think, an implementation. It's consistent with the natural law tradition. It's consistent with the natural law, but not required, because there's creativity in how the Supreme Court justices implement and cash out the meaning of the Commerce Clause. So I think the American legal system is full of positive law, but that in fact is an entailment of the natural law tradition, which says that the natural law itself doesn't fully determine how humans should live, either themselves individually or in a community, and that instead the natural law says humans in your creativity, in light of your circumstances, design yourself how you're going to live together in a healthy and happy community. And that our Constitution's text, original meaning, and precedent are the key ways that our system does that.
It sounds like the entire legal system is positive law. How do you show that natural law is a premise of the positive law? Does it still have a role to play after positive law has been developed?
Criticism of the position that I articulated, which is that the American legal system, in its positivity, is in fact entailed by the natural law tradition. Somebody might criticize it by saying that it doesn't seem like the natural law is actually doing much in that system. And I don't think that's accurate in a number of ways. But let me say one thing first, that the United States today has a mature legal system. It's been in operation for over 200 years. We've got a foundational text that is widely recognized, and we've got institutions that have been implementing that in detailed ways that have kind of built out the legal edifice over 200 years. And in that kind of a legal system, there's actually not a lot of space left for pure ethical norms to do work within that system. And so it wouldn't be surprising today if direct appeals to natural law norms are relatively rare in our legal system, although they could have been more common. In fact, they were more common at the beginning of our legal system. When you look at cases, for example, Fletcher versus Peck, you see Chief Justice Marshall referencing not just the Constitution's text in original meaning, but also his perception of what ethics required in that case as additional reason for the interpretation that he was offering for the Contracts Clause. And so you saw more of that early on, but then once you have the precedents in place, you no longer need to, or at least there's not as much of a need to appeal directly to ethical norms as there was when you didn't have precedents in place. In fact, the lack of appeals to natural law norms is evidence of the proposition I was arguing for, which is that the positive law is this implementing mechanism of the Constitution and of the natural law commitments to pursuing the common good. And so one should not directly appeal to the natural law when you have the positive law doing that system relatively well. What role does the natural law play in a mature legal system like our own? When I think of the U.S. Constitution, I think what the natural law tradition does is it allows us to better understand, to better explain, and to bring to the fore things that might otherwise be hidden from us. Let me give you some examples. So when you look at the preamble for the most part plays no role in American constitutional law. And I know when I was a law student, I found that to be relatively surprising. And I actually think that's the right position. In other words, that the preamble isn't there to provide a directive legal guidance to American officers or American citizens. But the preamble plays literally no role, or almost no role, in American constitutional law. But when you look at the preamble is evidence of what were the purposes of the framers and ratifiers in drafting and adopting and then implementing the Constitution. And when you look at what the preamble is saying is, it's not saying only that we're trying to protect natural rights, or the preamble is not saying only that we want to facilitate the democratic processes of the American people. It's saying those things, but in addition to that, it's talking about other components of what in the natural law tradition we call the common good. So for example, justice. So justice is a substantive commitment about how humans as individuals should treat each other and how humans within a community should be treated by that community and other members of that community. And the preamble references that directly. And so I think when you look at the text of the preamble in the natural law tradition, it brings to light that the purpose of James Madison and the other framers and ratifiers was they saw that the Articles of Confederation was not adequately securing or pursuing the common good, and that this new project, this new Constitution, was meant to secure the common good. So the natural law tradition, I think, brings to the fore things that might otherwise be hidden from us. Second, I think the natural law tradition allows us to appreciate aspects of the American legal system that we certainly know that they exist, but maybe we don't understand the importance of their existence. And I had mentioned earlier precedent or stare decisis. It's always been the case in the American legal system that judges, both state and federal, have created and then later followed precedent. Not uniformly, but stare decisis is this nudging, is this instruction, is this weight, this gravitational pull that later judges feel. And from the natural law tradition, what you see is that the goal of the Constitution is to secure the common good. The common good is the ability of Americans to live together in relative peace, to in the technical language, to coordinate our activities with one another.
You've now mentioned precedent a couple of times. How is that an example of positive law informed by the natural law?
And as I mentioned earlier, the spare original meaning of the text of the Constitution can't do it by itself, and that it needs to be implemented, it needs to be fleshed out, it needs to be built out through other mechanisms. And in our system, I think wisely, precedent is that key system. So I'll just give you an example. In the 19th century, you started having the phenomenon of railroads, and you had people in one state, a manufacturer manufacturing a product, putting that product on a train car, traveling through a series of states to a destination where it was going to be sold in a retail location. And the question the Supreme Court faced was, can a state along the route over which the product traveled on the railroad cars regulate that product? And the cases came out, for example, from the issue of gambling. In the 19th century, some states allowed gambling, some states didn't allow lotteries. And so can a state that doesn't allow lotteries prescribe the transportation of lottery tickets manufactured in one state across that state's boundaries to a destination state that does allow lotteries? And what the Supreme Court held was an application of the meaning of the Interstate Commerce Clause. Now, the Interstate Commerce Clause, as I said, is just a few words. And what you see in these series of cases in the 19th century, the court came up with the original packages doctrine. The original packages doctrine is the idea that the Interstate Commerce Clause authorizes Congress to regulate the transportation of commercial goods across state lines in their original packages. So if the lottery tickets were in the original packages from the manufacturer across state lines, then the transporting state could not regulate those lottery tickets, couldn't ban those lottery tickets. That conclusion, I don't think is obvious to somebody who looked at the original meaning of the Commerce Clause, but we needed, as a legal system, as a country, an answer to that kind of a question, to the question of what's the relative regulatory authority of states over these packages crossing their state lines. And the Supreme Court, in that precedent, came to a conclusion, applied the original meaning. That precedent, that conclusion itself became a part of American positive law, which had stare decisis effect, which then later continued to be applied up to today. And so I think what you see is, from the natural law tradition, is that the stare decisis is a key mechanism for the Constitution's original meaning to coordinate Americans, to coordinate American states, American officials, and that the natural law tradition allows us to see that the whole point of the legal system is coordination. I think the third important way in which the natural law tradition continues to play a role in our legal system is in describing the normativity of the Constitution. So it is the case, I think this is a sociological fact of American life, that most Americans, nearly all Americans, believe that the Constitution has authority. It has authority for officers, and it has authority in our own lives to the extent that it applies to us. Now, what explains that fact? Now, the natural law tradition has an explanation. The natural law tradition says that a key part of law is its normativity, is its claim upon the citizens of that community, the subjects of that law, to give reasons to those subjects to act in a certain way or to not act in another way. And in the natural law tradition, the key explanatory reason is the capacity of the law to secure the common good of that community. And I think an analogy might help. So all of us, or almost all of us, live in communities where we have speed limits. We drive cars, we go to places for work, for leisure, for knowledge, for family, for friendship, for religion. And so it's almost an essential aspect of American life. We're all familiar with the highway regulations. And the highway regulations are sometimes onerous. None of us like to get, for example, a speeding ticket, but it is a rare American who says that if they were speeding, that the law's application to them was unjust. In other words, if they get a speeding ticket, they were going 65 and a 55. Now, of course, you might say the speed limit should have been 65, but if you broke the law, people recognize that the law is obligatory on them. And what explains that? It's because of the ability of speed limits and other highway regulations to allow all of us to live together in a community with relative ease to be able to coordinate our activities. And I'll give you an example. I'm a father, and I've had a number of children who've had to learn how to drive. And there was one time where I was with my son, we were driving up to a four-way stop. And if you know the rule, which is the rule in every state, is that the person who comes to a four-way stop on the right-hand side gets to proceed first. My son didn't know that rule. So we pulled up first to a four-way stop, and then there was somebody to our left, and we sat there, and we sat there. And the other guy started honking, and my son looked at me because he didn't know how to coordinate his activities with the other driver. And so the law's purpose is to allow us to coordinate, to live together in peace, and the other driver was trying to follow that law because he wanted to be able to pursue and use the highways in a reasonably effective way. My son didn't know what the law was, and so the coordination broke down. But as soon as he learned what it was, which is when I told him that the person on the right gets to proceed first, then he immediately started to proceed first. And so I think we as people who live in a community governed by the rule of law, even in these mundane ways with highway regulations, recognize the normativity, the obligatoriness of our just positive law. And the same thing applies to the U.S. Constitution. It explains why it is that Americans of all different political and religious and other backgrounds look to the Constitution as providing reasons for them to act in certain ways or not act in other ways. And the natural law tradition gives an explanation for that I think is persuasive.
Thank you for listening to this episode of the Number 86 lecture series on jurisprudence. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number86 for lectures and videos on federalism, separation of powers, the judiciary, and more. Thanks for listening. See you in class.